This case happened when the plaintiff required the assistance of an ambulance. The paramedic decided that she needed to be taken to hospital, but when the stretcher was being loaded into the ambulance, one end collapsed, which resulted in further harm. Under the Civil Liability Act in Queensland, a range of organisations are protected from liability if they are rendering first aid to a person in distress, as long as their actions are in good faith and not grossly negligent. The Queensland Ambulance Service was prescribed as one such organisation. However, the statute which established the Queensland Ambulance Service was somewhat odd. The organisation itself was an unincorporated organisation, so it didn't actually have any legal identity. All of the paramedics who worked for the Queensland Ambulance Service were actually employed by the Queensland State Government, and the Queensland State Government was not one of the organisations protected under the Civil Liability Act. The court had to work out how to sort out this mess. It was pretty clear that the intention of Parliament had been to relieve the Queensland Ambulance Service of liability for negligence claims when paramedics were trying to help people in distress. And that's a pretty good policy objective. But the plaintiff wasn't suing the Queensland Ambulance Service, so the ambulance service was still protected. The question was whether the protection for the ambulance service extended to protect the state government as the employer of the paramedics. The court found that the protection did not extend to the state government. Justice Boskill said, "It may be correct to say that in the present case there was no cause of action against the Queensland Ambulance Service itself, but that is explicable by the fact that the claim was brought against the negligent paramedic's employer, the state, on the basis of vicarious liability. The Queensland Ambulance Service is not the employer and therefore has no vicarious liability." As a result, it is clear that the court is not going to exclude an injured person from obtaining damages for negligence unless it is really clear that the exclusion operates, and if the plaintiff can find anyone or any organisation to sue who is not protected, then they may still be liable no matter what.